Good morning.
You are no lawyer.
Good morning,
Yeah,
Bernard.
I hope you're well.
I'm very well by grace.
Let me just say from the very beginning that nothing you say will convince me that my position is right. But for the sake of what do they
Is
call
it
it?
about me?
Educating our listeners there, I will ask the necessary question. But when I'm sure we just played back what Phyllis said about what he knows is that she was still being held in prison custody, even though she has been acquitted and discharged. Their reason is that they are considering filing a particular process in the Court of Appeal or something. Is that enough grounds for you to continue to hold someone as a state that has been acquitted and discharged?
Well, I didn't hear exactly what you said about Felix. You said you played.
Yes. In fact, he spoke to Channel 1 TV, and he says that she's still being held in prison custody because I think they were planning to. They file a process with the Court of Appeal, and that's why she's being held.
Okay. I thought you said he had said that they were planning to file something, and I was going to say that planning to file something is not sufficient basis for holding someone who has been acquitted by a court of competent jurisdiction. That plan is not law, it's no order, and will not restrain the prison authorities from carrying out the orders of the court. However, the clarification you made that some process has in fact been filed, then I think that will convince me that there is some pending matter to be determined.
But even if the process has been filed, does that in any way hold so the court has made a decision? Does that automatically mean whatever decision the court has made, the implementation should stop?
Well, I don't know what has been filed, but if indeed it was an appeal filed by the Supreme Court against the judgment of the Court of Appeal acquitting Madam Sedina, the pendency of appeal in itself will not serve as a stay of execution of that judgment. But I'm also hearing that the Attorney General, upon lodging the appeal, also filed a motion to stay execution of the judgment or orders of the Court of Appeal, which automatically, given that the legal vacation started with effect from 1st August until October, then that application for stay of execution is not likely to be heard until then. Then in that case, the prison authorities may say that they'll hold back for a while.
If you file for a stay of execution, so she will be kept in there for this August, September. You said they are returning in October?
That is so.
For the next 2 months?
Will be around 10th or after 10th of October.
Wow.
We are on vacation now.
I see. Then why not release her? And if the court does grant what you want, you to pick her up again?
That decision will be one to be made by the prison authorities, because once there is a judgment that acquitted her, it takes immediate effect, and the rest will be administrative. That is for the prison authorities to execute the necessary discharge warrants and other processes that they use to have prisoners freed from their custody. And so these administrative processes are solely within the discretion of the prison authorities. However, when they think that there are processes or proceedings still pending in court that they will have to abide, they may hold back. I can't speak for them. Maybe you have to speak to the prison authorities and to find out whether there is any fetters to their powers of discretion, given that there is an express order or judgment from a court of competent jurisdiction which have not been set aside yet.
Yes, and because I also in this instance, there's only one judgment of the court. There's only one order that has been made. No subsequent orders have been made. I don't know. Are prison authorities supposed to act based on what has been filed by one party or the other?
Well, in this particular case, the prison authorities are not even parties to that action, which went for the court of appeal, upon which the judgment was given. And I believe by extension, the prison authorities are not parties to any pending appeal before the Supreme Court. However, whatever the prison authorities do, they carry out the orders of the court. They are part of the processes of execution of judgments, particularly those involving criminal conviction. And so it would not be unusual for them to follow all that is going on in matters in court concerning persons that they hold in custody on the orders of the court.
I see. Because, like I said, we're all critical when Gregory Afoko was held after he was granted bail. The state had decided that we are the ones holding you. We'll release you only after we are satisfied that whatever challenges we have to this decision have been well dealt with. And they held him. They never released him on bail, even though bail was granted to him. It looks like in this case, it's also the state deciding that until we are satisfied, we are holding you. It doesn't sound like as if there's any plausible reason for holding her, does it?
Then I think the two scenarios are not the same at all. So I was trying to compare mangoes, oranges in this case. In the case of Gregory Afoko, if my memory will serve me right, I think there was grant of bail. There was even, I think they were discharged at the point. They were rearrested. There was an express bail granted by the court, which was not even appeal or set aside, the best of my knowledge. In that case, it was...
Actually, the Attorney General has challenged, in fact, Godfrey Adami had challenged the decision of the court in another court.
Oh, okay.
Yes.
But there seem not to be any court proceedings or processes or orders that tie the hands of the prison authorities from their duty to relation, but simply the government of the day was unwilling to allow the law to take its course. In this particular case, I don't think that the executive arm of government, that is to say the office of the Attorney General, is using any extrajudicial processes to frustrate rule of law.
But they are the same state. They control the prison
General
service, don't they?
File an appeal against the decision of the Court of Appeal and follow that with a motion for stay of execution. In other words, was trying to freeze the effect of the judgment till the final determination of that appeal. And it is on the basis of this that I believe the prison authorities are holding back. But for the vacation, the legal vacation that has started effective 1st August, I believe the return date on the motion for stay of execution, I haven't cited it anyway, would have been a matter of days. And depending on the outcome, then we'll see what the prison authorities will do next, or the Attorney General will do next. Assuming that that application failed, of course, the tendency of the appeal alone will not be sufficient to tie the hands of the prison authorities. But in any case, I believe this application for stay of execution in the first instance will be lodged at the Court of Appeals, whose decision has been appealed. And assuming that it doesn't succeed, the Attorney General will still be entitled to repeat the application at the appellate court, which is the Supreme Court in this case. So there are 2 layers. The failure of the application at the court below, that is the Court of Appeal, whose decision is appealed, will not deny the state or the Attorney General a second chance of a repeat application at the Supreme Court.
And to end, and just for the sake of emphasis, this is Nilate joining us on Facebook. At what point can a prisoner be released from prison after the court has acquitted and discharged him? As far as you know, just for the sake of emphasis.
Statutory timeline. It's immediate.
Immediate.
It's immediate. I mean, once the judgment is given and there is no fetus legally to tie the hands of the prison authorities, it's immediate.
Thank you very much. Like I said from the beginning, nothing you say will convince me. But thank you, as always. It's a pleasure talking to you.
So you are going to listen to me and not be convinced.
Oh no!
To me anyway.
No, yes, because I don't really. My job is not to serve myself; it's to serve my listeners. And you are always fantastic when it comes.
But I'm also one of the listeners.
So you are educating the other listeners. In this instance, I refuse to be educated. So
okay, yeah. All right. So,
thank you. Thank you.
I have benefited from the conversation myself.
Yes.
Although I'm also not convinced like yourself.
Oh. Thank you very much. As always, I wish you the best of the day.
Same to you.
No. Well, I think that's exactly 48 minutes past 7 here in the studios of Radio Gold 90.5 FM. And Nancy this morning has the intention of raising issues that will just annoy me. Anyway, to be very frank, like I said, I'm still not convinced. I think that if they are holding her, they should release her. There's no reason to keep holding her.
So have you gotten the understanding now?
I still think that it is, ultimately comes down to who is holding her. It's the same state. It's just the same abuse of power I accused Akufo-Addo of when it comes to the Gregory Afoko matter. So in this case, I hold the same view. My view will not change, no matter what you say. My view will not change.